Hello aspirants, welcome to Excellence IAS Academy. In the earlier video, we have discussed about recusal. I hope you have got some conceptual clarity about recusal, what is recusal and how judges recuses themselves and what are the reasons with respect to recusal. In this video, we will discuss some of the very important Supreme Court judgments with respect to recusal, what the rules have laid down by Supreme Court in those cases. Let's begin. Firstly, Ranjit Thakur versus Union of India. In this particular case, Supreme Court have said that when a judges recuses themselves, they should consider the perception or the situation in the perspective of the parties involved while recusing themselves from the particular case. They should not only consider their minds or their perspectives with respect to that particular case. It may lead to biasness, or it may lead to arbitrary recusals, or may lead to arbitrary involvement in the particular case. So, in this case, Supreme Court have highlighted that the perspective of the parties involved in that particular case matters the more than that of judges, perspective of the judges. In second case, Shivanand versus State of West Bengal. In this case, Supreme Court defined what is biasness, means judicial biasness. It is said that it is a preconceived notion about particular issue or a predisposition about the particular issue, about particular matter. So, it may lead to, it makes judges incapable of being open-minded while giving justice in that particular issue. Preconceived notion about particular thing. So, in this case, particularly, Supreme Court reiterated that justice not only be done, but it also appear to be done. This particular phrase we have seen in earlier video, where we said that because of this principle, recusal came into picture in the judicial system. In this particular case, Shivanand Patak versus State of West Bengal, Supreme Court reiterated this particular phrase. Thirdly, in Skara versus Union of India case, also what we call the NJAC case, famous NJAC case of 2015. In this particular case, Supreme Court has said that when a person or a judge have a pecuniary interest in particular case or particular issue, in that situation, real danger test should not be applied, not a mandatory, because in that particular case, recusal becomes automatic, means pecuniary interest. Pecuniary interest. When a judge have pecuniary interest in some issue, in that case, recusal become automatic. And when a judge doesn't have any pecuniary interest, in that case, a real danger test should be conducted, or real danger test is mandatory. So, based on that, it is up to the judge whether he should recusal from that particular case or not. In this Skara cases versus Union of India, Supreme Court have laid down the rule called real danger test. And what are the issues with respect to recusal? Because when judges recuses himself, there are some issues associated with the recusal. What are those issues with respect to recusal? First one is that arbitrariness, because there is no defined rules and regulations present in the judicial system with respect to recusal. Judges may recuse themselves from arbitrary without giving any reasons, right? So judges may misuse that particular concept while giving or delivering the justice. This is one of the issues. Second, it may lead to transparency issue in judiciary, because when judges recuses themselves, they don't give reasons in some cases, as we seen in chief judge, for example, Bhima Koregaon case, Balkis Bano case. So it may lead to issue of transparency or accountability, trust issue on the judicial system. People oftenly misjudge or lose trust in the judicial system. That is the one of the issues. Thirdly, delay in justice delivery system. When judges recuses himself from particular case, a new judge should be assigned in that particular bench to that particular case. So it may lead to delay in the justice system. So that is the one of the issues. And India is a democratic country, right? And independent judiciary and judicial integrity is one of the core principles of democracy, right? So it is very much evident that if we want to protect judicial integrity, fairness, or the trust of the people on the judiciary, we should bring some codified laws and rules and regulations with respect to recusal, so we can make it more transparent and accountable. And also judges should give reasons in particular case why they are recusing themselves. And also when it comes to recusal, judges consider the perspective of the parties involved as highlighted by the Supreme Court while recusing themselves. These are the measures can be taken while recusing in from the particular cases. So as I earlier said, India is a democratic country. To protect judicial integrity and fairness in judicial system, and also enhance the trust of the public on judicial system, all these measures can be taken. Thanks for watching the video. Stay tuned for more such videos. Thank you.